Thank you very much, Judge Daly, and thanks to Gala for inviting me today. I really enjoyed the morning session. Thanks to the speakers also speaking to us from the social work perspective. My perspective is very different. It's from the legal perspective. And I framed the title around rights and responsibilities because as a lawyer, while we can talk about best practice in social work and professional work with children in care, as a lawyer, ultimately, without a right, there's not a corresponding responsibility. And when I litigate, when I act for clients, I need to identify a legal basis for what I'm seeking. The rights ultimately are the legal basis for what I'm talking about here. I have a paper as well as the PowerPoint slides that are in your packs, and if anyone wants the full paper with all of the references, Tigala can, I'm sure, email that to you. I have no difficulty with sharing it. So in talking about the rights framework for children in care, which includes children from ethnic minority backgrounds, I think the guide that has been prepared, that I think we'll hear more about later on this afternoon, mentions the Convention on the Rights of the Child, and it's something I just thought I'd briefly refer to in my talk also. The Convention on the Rights of the Child, which Ireland signed up to in 1992, includes a number of important principles that are relevant for children generally, children in care, and children from ethnic minority backgrounds in care as well. So I've just included on the slide there some of the key articles that are relevant to the issues that we're talking about today. Article 2, which is the principle of non-discrimination, one of the four guiding principles that informs everything in that convention, that in the enjoyment of all of the rights in the convention, there should be no discrimination on the grounds of various grounds, including race or ethnicity. Article 3, another of the core principles in that convention, that the best interests of the child shall be a paramount consideration in all actions concerning the child, including obviously care proceedings. There are a number of articles of the Convention that talk specifically about children who are separated from their families, whether by circumstance, by choice, or ultimately by state intervention. So Article 9 acknowledges the place of the child within the family, provided that's in the best interest of the child, and obviously there may be circumstances where that is not in the best interest, and that's where the care context comes in. Article 20 then talks about specific protections for children who are temporarily or permanently deprived of their family environment. And I think particularly relevant for our purposes today, Articles 29 and 30, which recognise specifically this cultural context and the needs in particular of children from ethnic minority backgrounds. So the rights of children in their education to have information and education around their cultural identity, languages and values. And in particular, the right to enjoy one's own culture, religion or language from an ethnic minority background. And the Convention on the Rights of the Child is obviously the leading international instrument. It's the most successful international instrument in the history of international law, in the sense of so many countries signed up to it without issue. Ireland signed up to this convention in 1992, but unfortunately we haven't brought those rights home, in the sense that for you to be able to rely on that convention in an Irish court, there needs to be a domestic piece of legislation to say that you can do that, basically. And we've never brought the Convention on the Rights of the Child into Irish law. So, having said that, when I'm talking about rights and responsibilities, why I'm talking about the Convention on the Rights of the Child is because I think there's a certain relationship that may yet be developed with our own constitutional values. I'm sure many of you know Article 42A, the Children's Rights Referendum, which has only recently come into force because of litigation actually around the referendum process, but it is now in force. And Article 42A talks about the natural and imprescriptible rights of all children, but doesn't actually define what those rights are. So one of the pieces of work to come in the years ahead, I think, will be litigation, the courts having to grapple with some of these issues. Well, what are the natural and imprescriptible rights of all children? And that's where I think the Convention on the Rights of the Child can be useful, because it does provide best practice guidance. It is almost universally accepted. And I think there may be scope for arguing that within the scope of our Constitution, some of the rights of the child may be similar to those that are stated in the Convention on the Rights of the Child. And I've just set out there the other provisions of Article 42A, which recognise the right of the state to intervene for the purposes of child protection in appropriate cases. There are provisions on adoption. The best interest principle that we have in Article 42A isn't universal in the sense that Article 3 of the CRC says in all actions concerning children regardless. Article 42A.4.1 limits the best interest principle to two specific contexts, but one of those is where the state is intervening in the family for child protection purposes. So for our purposes, certainly there is a best interest principle that is now written into the Constitution that applies directly in care proceedings. And we all know also the importance of the voice of the child. It's long been recognised in the Child Care Act and in the practice, but it's now also written into the Constitution in Article 42A.4.2. So in terms of the context of my paper, and we've heard already from Carol and Anne about the changing context of Irish society, the changing demographic, And I'm not going to talk about the issue of over-representation, I'm not qualified to, but certainly we do see representation of that changing demographic in all of our work, I'm sure. The fact that as Ireland has become a country of inward migration as opposed to emigration, the profile of cases that are coming before the courts, certainly the cases that I would work with, reflect that changing demographic in Irish society. So the issues that I wanted to talk about today I broke down into three broad headings in terms of areas where I think legally there may be issues to talk about. And the first deals with the issue of reception into care. How do children from ethnic minority backgrounds come into the care system in the first place? And this is from the legal perspective. The primary modes are either voluntary care, and I think Section 5, homeless children, also is invoked. My understanding is Section 4 is primarily the mechanism that's used in relation to separating unaccompanied children, and then alternatively care proceedings under Part 4 of the 1991 Act. I'll speak a little bit about the situation of unaccompanied separated children. I think there certainly are some people here who work with children in that cohort, and many of you may indeed in the future work within that cohort in terms of the specific needs of children. The issues arise here from a legal perspective around the scope of Section 4 of the 1991 Act, which says that the Child and Family Agency can take a child into care where that child has been essentially abandoned, where there's a child who requires care protection that they're unlikely to receive. The Child and Family Agency may take the child into care. But the scope of care under Section 4 is very different to the scope of the care orders that the District Court can make under Part 4. And in particular, the powers of the Child and Family Agency in respect of a child in voluntary care on the face of the 1991 Act are actually quite limited. Section 4.3 of the 91 Act says that where a child is in voluntary care, the duty of the Child and Family Agency is to maintain the child and to have regard to the wishes of the parents of that child in the provision of care. It doesn't go any further than that, and I think there may be cases ongoing or in the future around precisely the scope of power of the Child and Family Agency in relation to children in voluntary care. But certainly a child in voluntary care under Section 4, there is no severance of the parental responsibility, there's no transfer of parental responsibility to the Child and Family Agency, and that can raise issues in practice. In terms of the children who are in voluntary care in the asylum protection process, we've had an issue in the past around the equity of care that those children received in terms of being accommodated in asylum seeker accommodation rather than in foster care. But thankfully, as a result of a lot of work over the last few years, that policy of equity of care is now in place, and there is a pathway for children under the age of 18 to move into foster care where that's appropriate for them, notwithstanding the fact that they're in the asylum process. But the important thing to bear in mind there is that once the child ages out at the age of 18, unlike the normal aftercare provisions, those children, if they're still in the protection process, will be moved into direct provision. And I'm sure all of us here have heard mostly negative things about the direct provision process. It is a source of great concern, the standards of care that are received, the length of time people can stay in direct provision. One of the issues with direct provision is that it's linked with a policy of dispersal, which is that the direct provision centres tend to be outside of major urban centres. So isolation, social isolation, the lack of an ability to work for so long as a person is in direct provision, all of those issues impact on everyone in direct provision. But for an aged out minor coming from foster care into that context, I think there can be additional vulnerabilities and concerns. And the reason I'm highlighting this is that I think it really underlines the importance of speedy determinations of the applications for protection by unaccompanied minors and separated children. Because the Section 4 process happens outside of the court process, some concerns have been expressed about the lack of court oversight, for example, that there's no guardian ad litem. And I'm not saying that that has to happen in every case, but I think it does place an additional responsibility and an onus on social workers acting for those children to advocate very strongly on their behalfs for prioritisation of their cases so that they are, if possible, resolved before the child reaches the age of 18. That's so that to avoid, in the first instance, the prospect of the child moving into direct provision at the age of 18, but it can also have a really important impact on later rights for the child. For example, the right of family reunification. If a child is recognised as a refugee or somebody who's entitled to subsidiary protection, they may have the right to have their family members join them in Ireland. But once they turn 18, they lose that right in respect of their parents and their siblings. So it's crucial, if the child is to have these rights, that they're secured for the child before they reach the age of 18. And for children in voluntary care, that responsibility solely falls on the social workers who are acting for them. I said I'd mention briefly the International Protection Act, which has just come into force because this is new for a lot of us working in the area. It's not yet enforced, but it's expected to come into force sometime this year, and it will affect, I think, a lot of the work that's being done with unaccompanied children seeking asylum or subsidiary protection. There are a number of provisions of that Act that I think are problematic from the point of view of the rights of the child and may cause issues for professionals, in particular social workers in practice. First of all, an unaccompanied child who's identified has to be referred to the Child and Family Agency. So if an immigration officer is dealing with somebody and they're concerned that the child is under 18, they must refer the child to the Child and Family Agency, and then the child protection framework kicks in. Under the Act, it's for the social worker to decide whether to make an application for protection on behalf of the child. A child has no capacity to make that application themselves. So whatever the capacity of a child, you could be talking about a 16 or 17-year-old with full capacity, but legally speaking under the 2015 Act, it's the social worker's decision, obviously in consultation with the child, but ultimately the responsibility lies with the social worker. Is it appropriate to make the application for this child? But also a question that should be asked, are there other applications that could be made on behalf of this child? A general immigration context, not just asylum or protection. There are issues around age assessment that aren't really addressed in this 2015 Act, that decisions around age-disputed minors are being made by immigration officers and not with input from child protection specialists, and that remains the position under the 2015 Act. It's concerning because there is a power to detain people over the age of 18 in the Act. And if there's a dispute about the age of a minor, basically provided that two immigration officers, two guards, or one immigration officer and one guard, provided they agree that this person is over the age of 18, they may detain that person. And I'm sure we all would want to see and want to avoid a situation where a minor, a person who turns out to be a minor, is actually detained in an adult prison. Given we don't have immigration detention facilities in Ireland, that would involve a child essentially being detained within an adult mixed prisoner population of convicted and remand prisoners. So there's a huge duty on the immigration side to make sure these decisions are right, but I think there's limited scope on the face of the Act for social work and child protection professionals to feed into that, but I think wherever we can identify pathways into feeding into that process to advocate on behalf of children, it's important that that is done. The 2015 Act allows for fingerprinting to be taken from children over the age of 14 for the purposes of essentially establishing their identity and basically running checks to see have they previously been in another EU member state. Consent is not required for that, and it's important to note that in respect of unaccompanied minors or separated children, provided that the social worker is present, the guards can take their fingerprint. The consent of the social workers isn't necessary, and these aren't children who are accused of any criminal offence. Concerns have been expressed by the Human Rights Commission, the Refugee Council and others about this legislation, but it's important to be aware that once it is in force, the guards will have these powers and social workers will be part of the process around that. Particular concerns arise under the Act about medical examinations, both generally and in specific for age assessment purposes. Under Section 23 of the Act, the Minister or an immigration officer can require a person to undergo medical examination in support of their claim for asylum. So, for example, if a person says that they're a victim of torture, that they're a victim of rape, it appears from the face of this section that they may be required to undergo medical examination to prove that. There's no reference to consent in that section, which is a fairly fundamental feature of most medical processes, and I have to say I'd be interested to hear the Medical Council's view on whether medical practitioners should conduct these examinations without the consent of the individual. But specific age assessment medical examinations are dealt with in Section 24 of the Act. And this is an issue that I think is going to cause issues for social workers in the future. The Section 24 says that consent for a medical examination, they're probably told, it doesn't spell it out in the Act, but it's most commonly X-ray, bone density, dental examination to try to assist in determination of an age-disputed minor. Section 24 says that consent for a medical examination must be obtained from either the child themselves, an adult taking responsibility for the child, quite a worrying phrase because there's no reference to the legal responsibility of an adult claiming a child, and there have been trafficking concerns in that area in the past. But for our purposes, importantly, the other category of person whose consent can be obtained for these medical examinations on children is an employee of the Child and Family Agency who has made an application for protection on behalf of the child. So basically, if an immigration officer doesn't believe that a child is under the age of 18, They may require the child to be medically examined for age assessment purposes, and the social worker's consent is sought for that process. The issue that arises here is that my understanding of Section 4 of the 1991 Act is that a social worker may not have the legal authority to give that consent because the nature of Section 4 voluntary care is more limited. So I think the Child and Family Agency and social workers will have to reflect themselves and perhaps take your own advice on whether it is appropriate to give that consent without, for example, a court order under Section 47. I certainly think from my perspective issues may arise in the future in that regard. There's also broader ethical concerns around age assessment, medical examinations, because the margin of error tends to be plus or minus 3 years. So for the most disputed category between about 14 to 17, the usefulness of those tests ultimately is extremely limited. So there are ethical as well as legal concerns arising in that area. So that's all I'll say about the unaccompanied minor separated child. Moving on to care proceedings themselves, then under Part 4, this is the other context within which children from ethnic minority backgrounds may come into care. And I set out in my paper the relevance. We all know that the criteria for emergency care orders, interim care orders, full care orders and supervision orders. I won't repeat it. But we've heard mention already this morning of the basis on which children from ethnic minority backgrounds may come into care, and physical abuse, corporal punishment it certainly arises. And it's not an uncommon argument for parents in a situation like that to say it's a part of our culture. There's nothing wrong with it for where we come from, and we're simply incorporating our own parenting style in our discipline and essentially contesting the right of the state to intervene. So there's a couple of decisions of the district court on the court's website that I think are very useful. In the last 3 to 4 years, the district court has begun to publish judgments from the district court. It's a very welcome development. For my purposes, it's slightly difficult because none of the judges are ever identified, so I have to be very careful in what I say because I'm not sure who wrote it, but I'm not going to criticise any of them today anyway. But I've given you the references there if any of you are interested. There are 2 decisions on the court's website from the district court to do with this issue of physical chastisement in respect of children from ethnic minority backgrounds and that whole cultural context around corporal punishment. So the case of HSE and L, this was an application for a supervision order. There were, I think, 5 or 6 children in the family, and disclosures had been made in school about the use of physical punishment at home. And that ultimately led to the social work department applying for a supervision order in order to monitor what was actually happening within the home. The parents opposed that, saying they were both from ethnic minority backgrounds, and they said that this was a cultural norm for them, that there was nothing wrong with the use of corporal punishment. They said that they incorporated different levels of discipline within their home, but ultimately they did reserve the right to use physical discipline if other methods had failed. The social worker gave evidence, quite interestingly in the case, that all corporal punishment was harmful to children and that there was never a context within which it was acceptable. And the court was quite careful in this case to distinguish or to slightly narrow the approach on which the decision was made. The court did accept in general that corporal punishment may cause short and long-term distress and difficulties for children, and that this outweighs the benefits, if any, that you might be able to argue arise from corporal punishment. And the level of adverse impact on children increases the more severe the physical punishment imposed. The court was careful to acknowledge the cultural context, that the parents genuinely believed this was in their children's best interests, that this was, from the parents' perspective, a culturally normal and acceptable manner of discipline. But the court ultimately said, and this is the point, it's a very fact-specific decision related to the facts of this particular case, having regard to the ages of the children, the physical effect of the corporal punishment described, including the pain or discomfort caused. This is related, I think, to the disclosures the children had made. The frequency of the use of corporal punishment, the use of an implement, all taken together, the court said, did exceed the threshold for a supervision order and therefore constituted ill treatment. So the court wasn't endorsing the social worker's evidence that all corporal punishment will amount to ill treatment for the purposes of a care order, but based on the facts of this case, and that's the important point about linking the impact of physical discipline on the child in order to meet the threshold. It's also interesting in that case that the Child and Family Agency had asked for 3 directions along with the supervision order, one of which was that the parents would be directed not to use corporal punishment in the future in respect of the children. And the court refused that direction, saying that at the time there was a defence of reasonable chastisement for a parent using physical discipline, and that essentially the direction sought by the Child and Family Agency would criminalise conduct that actually wasn't criminal as a matter of Irish law at the time. So the court refused the direction on future use of physical chastisement. And I just mention here that the defence of reasonable chastisement has actually now been abolished as of 11th of December last year. And so I think in a future case, certainly it may be open to the Child and Family Agency to invite a court in the context of either a supervision order or another order under Part 4 for a direction prohibiting the use of physical discipline, because it is in fact now a criminal offence without excuse as a matter of Irish law. That's under the Children First Act. There's also the case of HSE and ON, so this is from 2011, and I just refer to it here because the court has an interesting passage in the decision distinguishing between a single episode of physical abuse by caring parents and intentional repeated abuse. Again, this was a case involving children from an ethnic minority background, and again, I suppose it demonstrates the need to ensure that a very fact-specific focused application is made to the court related to the particular circumstances of the individual child and not based on a generalised approach about the use of physical discipline. Although, as I say, the fact that we have now abolished this defence of reasonable chastisement may open this up for some further discussion. The court in HSE and ON also talked about the importance of cultural mediation, and we've also heard some references to that this morning. In that case, the court made the care order a full care order, but fixed a review for 6 months later and invited the parents to engage in cultural mediation around the issue of physical discipline in the hope that if the parents were capable of acknowledging past wrongs, that there might be a pathway to reunification in the future. But the court was careful to say that it would involve the parents accepting wrongdoing for that to happen. The next issue I want to talk about for children in care, and it's a particularly important one for me in the work that I do, both in the child protection and immigration context, is securing the status of the child in immigration law. And actually I was interested to hear from Anne that was one of the specific items that she had on her checklist of things that need to be done for children in care. So Section 18.3, when the Child and Family Agency has succeeded in obtaining a full care order, it has the like control over the child as if it was the child's parent. And it also must do what is reasonable in all the circumstances for the purpose of safeguarding or promoting the child's health, development and welfare. So we all know that. But the question is, what does it mean in particular in a case for a child from an ethnic minority background? And very commonly the work around securing and promoting health, development and welfare deals with issues like developmental milestones, physical, psychological, mental health, emotional well-being, education and so on. They're all issues we're all very familiar with working on. What I want to do is to advocate very strongly that a part of that decision-making process in cases for children from ethnic minority backgrounds is very specifically and carefully addressing at the earliest opportunity what is the legal status of this child in Ireland and does it require action. And there are a number of issues to this. The first issue is, of course, well, is this child going to remain in Ireland? Family reunification has to be considered, both within Ireland but also with extended family members outside of the country. But if a decision is made that it is in the child's best interest to remain in Ireland, then it is absolutely essential that the child's immigration status is clear to everybody. And that's a very challenging thing to achieve because actually our immigration system is extremely complex and complicated. I'm working in the area 10 years. I think I understand it just about, but there are still issues that come up from time to time that surprise me. A child who's an Irish citizen has a right to live in Ireland without condition or restriction. So the first question that has to be asked is, well, is this child an Irish citizen or is this child entitled to Irish citizenship? So a child may have citizenship by birth, depending on their parents' immigration status or their own citizenship. It involves detailed inquiries being made of the parents where that information is known, and if that information is not known, it may involve inquiries being made with the Department of Justice and immigration authorities to try to secure that information. If the child is not an Irish citizen, and if they are, by the way, they must have an Irish passport to prove it, because sometimes a person may think they're entitled, and when they apply for a passport later on, they're refused. So the passport is the crucial proof of that. If the child is not an Irish citizen, is the child an EU citizen? If so, is the child to remain in Ireland again? Should there be an Article 15 transfer to the country of origin? Or if not, what is the child's entitlement to be in Ireland? But in particular, and Anne spoke about this, as children approach the age of 18, the spectre of deportation becomes very pressing for some children from ethnic minority backgrounds whose immigration status is unclear. In my view, and I'm waiting for the day I can make this argument in a case if need be, a child who's in the care of the state cannot be illegally in the state because there's just a fundamental conflict with that situation. So if a child is in the care of the state and it's not a child in the protection process and that child is not a citizen, then I think there's a duty on the HS or the CFA to make an application for that child to have a formal permission to live in Ireland. And it's important that that's done before the child turns 18, because once the child turns 18, they may go into the general immigration process without the assistance and the weight of the Child and Family Agency behind them and in support. And it may leave the child very vulnerable in trying to navigate this incredibly complex and difficult system. In addressing this issue of the immigration status, children under the age of 16 in general aren't given an independent status. They simply derive their status from their parents, and that's why this issue arises. Well, if your parent, you're in the care of the Child and Family Agency, can a corporation give you an immigration status? Probably not. So in cases of doubt, I think an application should be made for an independent permission for a child. Certainly once they turn 16, they are obliged to have their own independent status, and they are obliged to register with the immigration authority, something in my experience that's often overlooked. A 16-year-old child who is not a citizen of Ireland must register with the immigration authorities, and failure to do so can cause problems later on also. But the type of status that a child is given then is also crucial. I had a case a couple of years ago where I advocated on behalf of, I think it was the Guardian I was acting for, this issue of registering the child. The child was then registered at the age of 16 and given a stamp 2, which the social work department thought resolved the issue. Yes, this child has now an immigration status, it is a stamp 2. So there are different types of immigration permissions, and I won't bore you all with the details of it, but the important thing to be aware of is that a stamp 2 it's what's generally called a student permission. It's a person is allowed to be in Ireland for the purposes of studying, and they may work during holidays. That might sound entirely appropriate for a 16 or 17-year-old who's doing their leaving cert, but the important thing to note is that a student permission is time limited. You can only stay in Ireland for 7 years on a student permission, at the end of which you must leave. And very often I think these children in care are probably entitled to a much broader type of immigration permission that's called a stamp 4, which is a full right to reside. It leads a pathway to citizenship in time if that's what the child wants. So I'm not expecting everyone to become experts in immigration law, but what I'm saying is I think very early consideration has to be given to these issues, and if necessary I think social workers should take legal advice from the Child and Family Agency's own legal representatives around this issue so that the necessary applications can be made as early as possible, because it also takes time. The immigration authorities are notoriously slow in some areas, and so these issues really do, I think, crucially have to be resolved before the child turns 18. So, as I say, as part of the responsibilities of the Child and Family Agency towards a child in care, I would certainly urge very strongly that attention is given to this issue of the legal status of the child while the child is in care. And the final issue that I'm going to talk about just briefly is religious and educational instruction. And I speak very tentatively in this area because it's obviously a hugely complex and hugely sensitive issue. But disputes can arise between the parents about the religious or educational instruction of their child. The parents may be divided between themselves, or they may present a united front to the Child and Family Agency to say they insist on a particular type of religious or educational instruction that has an impact on the placement, the schooling, and many other aspects of the child's life. If agreement can't be reached, then obviously an application can be made to court. I think there's some debate about whether those applications should be made under Section 47 or under the Guardianship of Infants Act if there's a dispute between the parents. But ultimately, if it's going to come to court, how does the court resolve the dispute? Very carefully and very warily, I suspect judges aren't very keen to try to resolve these types of issues because of the complexities and the sensitivities. But what I can say in terms of the guiding principles, certainly from the European Court of Human Rights, there's this case of Hoffmann in Austria that said these kinds of decisions cannot be based on an assessment of the relative merits of different religions. And that's exactly the kind of issue the courts have to stay very clear of. Is it better for this child to be raised in this religion or the other? What are the advantages and disadvantages of these two religions? That is simply not an acceptable exercise. The English courts have done a lot more work on this because they have a much more established history of migration, as Anne also noted. Basically, the jurisprudence from the English courts, and it's in my paper if any of you want to see, you can get the references from it. They talk again about the importance of a fact-specific determination in each particular case. So an assessment of the parents' own religious and cultural backgrounds and the strength of their beliefs, the extent to which the child was exposed to those factors. Was the child removed at birth, or has the child lived within that context, and to what extent is that a factor in the particular case? In general, The courts in England won't make orders directing that a child is to be raised in either one religion or the other. They prefer to perhaps leave it open and to say that the best that can be done in disputed cases is that the situation is left open for the child. Hugely sensitive, as I say, hugely complex, but ultimately the key point is that each case has to be decided on its own. Objective, independent evidence around these issues is also very helpful to the courts in trying to make decisions to avoid that idea that the decision is ultimately being made based on an assessment of merit of one religion versus another. The fact that we don't have any decisions from our courts on this issue tells me one of two things. Either the courts don't want to deal with these issues, or as I say, they're wary of treading into this very difficult area. But also I think it tells us that the courts are keen to see people resolve these issues outside of the court process, that these are ultimately not things to be resolved by court order, if at all possible. And certainly in the cases I've been involved in where this issue has arisen, it is an area that the judges have very keenly impressed upon everybody the role of cultural mediation to trying to resolve the issue without having a court order against one side or the other. So in conclusion, the legal issues that arise for children from ethnic minority backgrounds in care are varied and complex, and we all know that working in it. The courts have a very difficult job in trying to resolve the disputes that can arise, and there is, I think, limited Irish engagement from the courts with these issues. That probably does reflect the fact that our demographic has only changed in the last 10 to 20 years. So I think we will see more of these issues in the coming years. I do think there is definitely a preference on the part of the judges to encourage mediation where that's possible, rather than to impose a solution on the parties in this very sensitive area. But as I say, from my perspective, in the legal context within which I work, I think it is hugely important that all professionals working with children from ethnic minority backgrounds are aware of the specific issues that can arise around reception into care. Is it a case that it's appropriate for Section 4 or 5, or is it a case where Part 4 orders are necessary depending on what's happening in that particular child's life? What is the child's immigration status in Ireland, and what can the social work department do to secure that? And the issues then that do arise and that will arise in the future around religious and educational instruction. Thank you.